Hello, Hinkai. Are you there?
Hi, yeah. So shall we make a start?
Yes, I think if we can, that would be great. Yeah.
All right. So perhaps let me make some introduction first. Thank you everyone for joining us this international workshop on intellectual property right challenges from emerging technologies. We have a lot of online participants. Good evening or good morning, depends on where you are. And actually, we also have a lot of on-site participants here. So before I pass the time to our opening remarks speaker, perhaps allow me to introduce the guest today first. Okay, we have Professor Sue Price from University of Exeter, our opening to deliver an opening remark to us. Perhaps you can show your face to us, Professor Price.
Hello, I'm here. Can you see me?
Okay.
Hello. Yeah.
Hello, and we also have Professor Price is head of law school in University of Exeter. So we also have Professor Martin Lockett here, our Dean of Faculty of Business. Yeah, and we have two invited keynote speakers. The first one is Professor Richard Everson. Richard, are you here?
Yes, hello. Hello,
yes,
thank you.
Hello.
Hello.
Thank you very much. And we also have Professor Ma from Fudan University. He initially actually planned to join us here on site, but because of COVID situation in Shanghai, so he's not able to travel. So Professor Ma, are you here?
Okay, hello everyone. Good afternoon or good evening. Okay, good morning. Okay. Okay, hear me?
Yeah. Yeah,
okay.
Sure.
Thank you.
Very clear. So I will pass the time later to you when your speech time is scheduled. Okay. So we also have our associate dean on RKE Research Knowledge Exchange here, Professor Martin Liu. Okay, another Martin. Yeah. So without further ado, oh, actually, I forgot to introduce myself to you in case you don't know who I am. My name is Hinkai, Professor of Operation Management from Business School here as well. So today, actually, the reason we organized this event is because we have an HRC project. You can see the title on the screen. This is also a joint kickoff event. And James is my collaborator for this project. So I would like to pass the time to James first. James, please.
Okay, hello everyone, welcome. I didn't know I was doing an introduction, you put me on the spot. So it's a great pleasure to be here. Thank you all for coming to this event. I'm sure you'll find it very interesting. So we'll be talking about a lot of novel technologies in relation to 3D printing and artificial intelligence and blockchain. Certainly, I've already been able to have a look at the PowerPoint of Professor Richard Everson in advance, and it certainly looks a very intriguing talk. So, Hinkai, are we going straight into the presentations now?
Not yet. We have the opening speech, okay, from Professor Price and Professor.
I just wanted to check. So today will be a very, very interesting discussion. We very much look forward to hearing what everyone has to say, and please, if you have questions as we proceed, please do feel free to ask them. So we begin with some more general discussions after our introductions to the project. So some more general debates, and then we'll be going into the specifics of our particular projects. So at which stage then I'll revert back to Hinkai in order to introduce those giving our welcome and opening remarks. So thank you, Hinkai.
All right, thank you, James. So may I invite Professor Sue Price, head of law school, University of Exeter.
Thank you very much, and good afternoon to everybody joining us from China, and good morning from me in Exeter in southwest England. As you said, hello, I'm Professor Sue Prince. I'm the head of the law school here at the University of Exeter, and we're really pleased to be able to welcome you to this international workshop on intellectual property right challenges for emerging technologies. Extremely dynamic and current topic, And the University of Exeter prides itself on being at the forefront of technological research across disciplinary boundaries, and I think this workshop reflects that. Our Institute for Data Science and AI drives new collaborations and innovative approaches, and the law school itself sits in the College of Social Sciences and International Studies, and that college houses QSTEP, which is a multi-million-pound programme to encourage and improve greater research in applied data analysis. In the law school itself, we have the excellent SCHOOLY, which stands for Science, Culture and Law Research Centres, which is one of our multidisciplinary research centres, considering areas of IP, policy, regulation, medicine and the environment. And in the law school, we're currently advertising for our first international chair in AI and law. This is to show the importance that we put on technological innovation and the impact that it's having across all areas of legal development and the legal profession across the world. I wanted to thank very much the organisers of the workshop today, and I'm very sure that everybody participating in the conversation, that it will be lively, the energy levels will be high, and I hope you have an excellent, engaged and productive workshop. Thank you very much, and have a brilliant time.
Thank you, Professor Prince. I need to express my apology. I don't know why I read your surname as Price. Perhaps I'm getting older, right? Next, I would like to invite Professor Martin Lockett, our Dean of Faculty of Business, to deliver a opening remark. Thank you.
Thanks very much indeed, Hinkai, and thanks to everybody who's been involved in the organization of this session, both in China and in the UK. I'll give a few remarks very, very briefly about the business school here, and then something about what I hope we're doing in the business school. So we have around 3,000 students, including 175 PhDs, and that includes areas, obviously, of emerging technologies, and including one of our members of staff looking at law and AI, Ernest, who's here today. And obviously 3D printing in particular has been an area that Hinkai has been pioneering work in, together with PhD students. We've got around a little over 100 academics. And our goal is to be a very strong, leading international business school in China. So we're really delighted to be able to work with and welcome speakers from the University of Exeter, a leading UK university, and Fudan, a leading Chinese university. I guess we see ourselves as a bridge between China and the West. We've got a very international faculty, and we see our distinctive features, the fact that we can understand both. We can, in a sense, build a bridge between them. Now, some of that is about helping business understand what it's like to work in China, if you're a Western business, what it's like to work internationally, if you're a Chinese business looking to work globally. So we're very strong in that, both in terms of research, but also in other areas, including executive education. One of the organizations we work with a lot is CRRC, or Zhongche, which is the world's leading high-speed train manufacturer. So that's an example where it gives us insights into what's happening in some of those leading companies. We also work with Western companies in China, including manufacturers, service companies, and so on. So that's one aspect of our work. But we're also very interested, and this is one of the things where we're particularly strong, in building international collaborations. If you look in the areas of business administration management, we actually ranked, in the last time I did a detailed analysis, in the top 20 in the world for business schools of joint publications. So collaborative publication. Collaborative publication comes from working together on projects like this, and by choosing the areas that are of real interest. And so I think here, looking at emerging technologies, intellectual property, it really is very current issues. And I think we'll make great progress in this project and in the wider discussions. It's definitely an area where there's great interest. There's a lot to be done, both from a legal, a business, and many other perspectives, hence the interdisciplinary nature of this. I also know that there are a lot of lawyers, especially in the US, just waiting to get going on litigation to do with this. If we can provide some insights that then can help do this so that it can be a productive relationship that protects intellectual property on the one hand, but also doesn't mire people down in lots of intellectual property disputes. That will be a great achievement. So that in a way is my hope for this project, that it can help bring a measured approach, and one that can really inform policy, can inform businesses, and can inform future research. So that's all I want to say. Let me hand back now to Hinkai and our other speakers.
Okay, thank you. Before we start our presentation, actually we are going to take a group photo. We have an innovative way to do it actually here, because we have a very good facility, Harvard type of lecturer. So we will include both on-site participant and online participant for this group photo. So for the online participant, please turn on your camera. So you will be shown on a very big screen behind our on-site participants actually. So please, our on-site participant here to move over here. Yeah. Please take a seat here. Yeah. All right. Please get ready, online participant. Okay, let me do it. 1, 2, and 3. Okay, thank you. Now, James, I would like to pass the time to you so that you can introduce our first keynote speaker today. All right.
Okay, thank you. Right, well, I'm sure we all look forward to seeing the group photo. We couldn't actually see what it looks like on our webcams, but so we will look
later on you will see.
Okay, so our first speaker, I'm very pleased to be able to introduce Professor Richard Everson, who is based here at the University of Exeter. So as you can probably see from the slide at the moment, he will be talking about machine learning and artificial intelligence. So Professor Everson is a professor of machine learning at the university, as I said, and he's also a director of the Institute for Data Science and AI here in Exeter. Richard graduated with a degree in physics from Cambridge University and a PhD in applied mathematics from Leeds University in 1988. He worked at Brown and Yale universities on fluid mechanics and data analysis problems until moving to Rockefeller University, New York, to work on optical imaging and modeling of the visual cortex. Later, he was working at Imperial College London, and then he joined the University of Exeter back in 1999. So Richard's current research interests are in machine learning and optimization and the interplay between them. Current research projects include surrogate modeling and Bayesian optimization for the optimization of expensive to evaluate functions, such as computational fluid dynamic design problems, the use of novel data, such as social media, in predicting damage from high winds, the tracking by parts in video, automatic analysis of video for sewage inspection, linkage of accelerometer data to physical activity, and clustering to understand dementia diagnosis. He works closely with industrial partners on topics ranging from air traffic control to detecting lameness in cows. So a very, very varied career. So we look forward to your presentation now, Richard. So over to you.
Well, thank you very much, James, for that flattering or introduction. Makes me sound very old, which I probably am, and probably jack of all trades and master of none. But thank you very much. It's a pleasure to be here, and what I'm going to try to do is make some remarks about AI and machine learning in general. I'm clearly not an expert in intellectual property, so on. But I'll try and say something about the way that I think one or two of the developments in artificial intelligence, machine learning, are affected by those sorts of considerations. And then I'll try and say a little bit about how I think artificial intelligence is affecting the 3D manufacturing, the additive manufacturing world. So I'll try and share my, will I be able to share my screen? Let me try to do that first of all. Can you now see my screen? I now can't see anything.
Yes, we can see it. Yeah.
You can. Okay, perfect. Thank you. So when I was younger, and as James has pointed out, I'm not young anymore. The sort of idea of artificial intelligence was very much this idea of robots, walking, talking, sort of humanoid robots, and we still see those sorts of things in the science fiction of today, but very much brought to life through the novels of people like Asimov. And although we are starting, I suppose, to approach that sort of thing, at least we see sort of facsimiles of them walking around, we still haven't really got that far. But nonetheless, we think of artificial intelligence as coming of age, of being present in our lives, and we see, in our smartphones, every time we talk to a call center, every time we search on Google, all of these types of things that we do are mediated now by different types of artificial intelligence, some of them really quite deep, but some of them quite shallow as well. And what goes to make up this artificial intelligence these days, I think, is a combination, and I've tried to show them in pictures here, is a combination of two things. And one of them, of course, is data, and the vast quantities of data which are becoming available through sensing, but also through specific data collection ourselves. And then the other thing which goes into this, makes artificial intelligence possible, is high performance computing. The picture in the middle is about the only picture that I could find of a quantum computer. And if we really do get quantum computers over the next 5 or 10 years, which are capable of large scale computation, then that will make a tremendous difference to the possibilities of artificial intelligence. But since I've been in this sort of field, quantum computing has always been 5 or 10 years away, and I'm afraid it sort of continues to recede. Perhaps we're catching it up. But for now, the high performance computing part of artificial intelligence, I think, is this treatment of data by high performance computing, which means high performance computing in data centers largely. The use of data in general, and I probably won't touch on this, perhaps I'll come back to it a little bit later, but in general, that means that that brings up all sorts of intellectual property and the treatment of data, those sorts of questions. And I think those are really embodied by the FAIR principles, that data should be findable, that it should be accessible, it should be interoperable, and it should be reusable. So those 4 principles of fair data use. And I think that that pervades artificial intelligence and machine learning as we use people's data, and how that plays out in the 3D manufacturing space with new technologies is quite interesting. Oh, excuse my dogs. I'll just close the door. Okay, so what I'd like to do is mention a couple of projects that at the Institute for Data Science and Artificial Intelligence that we are involved with and are leading in various ways. Something I perhaps should have said right at the beginning is that the Institute for Data Science and Artificial Intelligence at the university here it's really important that it involves not just the technologists, but also the social scientists and the humanists who understand and have views on the way in which this technology affects our society and the way in which the technology should be developed so that it is useful to people in the society. And if we fail to do that, then I think that all is lost, really. And so I welcome this sort of workshop work. One thing that I would like to I'd like to talk about a little bit is the Joint Centre for Excellence in Environmental Intelligence at the university. This is a joint venture between the university and the Meteorological Office, the Met Office, which is also coincidentally based in the University of Exeter. Sorry, not in the university, in Exeter, the city. And this is aimed at using artificial intelligence to understand our environment and to look at the future of our environment and perhaps to mitigate some of the climate changes which we are all concerned about. And so this is using artificial intelligence to understand the climate, to monitor the environment around us, to use artificial intelligence to bring together very often sparse observations of, for example, particulate matter around the world, and integrate that into a global picture, which can then be used to help people understand how to mitigate some of those effects. One thing that I think is very important to think about when you are working with machines which are making predictions, and so I suppose this is machine learning now rather than artificial intelligence, is to understand the uncertainty which is inherent in those predictions. I think one of the fallacies of artificial intelligence is that it makes what appears to be a very certain prediction and we tend to just believe it. But I think wherever data is involved and projections into the future, we have to understand the uncertainties which are attached to those predictions. Let me move on to another project, which is this is a collaboration between NATS, which is the National Air Traffic Service in the UK, and is responsible for guiding or for air traffic control. So making sure that aeroplanes in the skies above the UK, across the Atlantic, are first of all, that they're safe and so that they don't become dangerously close to each other, but they also fly on efficient routes. And of course, this has bearings on the emissions that they make and ramifications for climate again. It's a large collaboration between NATS, the University of Exeter, and the Alan Turing Institute, which is the National Institute in the UK for Data Science and Artificial Intelligence. And it breaks down into three components, which I think are worth thinking about here. The idea overall is that we will be able in the future to be able to use artificially intelligent agents in place of or at least augmenting the work that is done currently by air traffic controllers. Of course, this is a very skilled and stressful job, and it's something which today is done almost entirely manually. All of the decisions are made manually by these very skilled air traffic controllers. In this project, we've got several components. We're building a probabilistic digital twin. So this is a twin, or an in silico twin of the airspace, parts of the airspace, and then the national airspace. And again, that is probabilistic, needs to incorporate ideas about uncertainty. Having built that, we're then able to train agents in order to do the machine learning, which can then control the aircraft in the sky. And while that might seem quite easy, it of course is it's quite a big problem to tackle from an artificial intelligence and machine learning point of view. But perhaps the even larger problem is the trustworthiness of those agents which the technical people like me, develop. And so in addition to this sort of intelligent agent control of scheduling, we need to have artificial intelligence which is trustworthy for the people who are going to use it, the air traffic controllers, but also the people like you and me who are going to fly in the aeroplanes which are guided by these intelligent agents. And of course that raises all sorts of questions about how trustworthy the AI is, and the sorts of perhaps moral decisions that might have to be made. And we see this type of dilemma being raised in perhaps the slightly more pedestrian case of autonomous vehicles, which we might see on our streets. The types of decisions that, where some type of accident is inevitable, do you make the decision to go one way and injure somebody like me, or go the other way and injure a baby? Probably pretty clear in that case, you drive towards me, but there are all sorts of moral and intellectual decisions to be made there. There's another project which I think is worth mentioning at this stage. I don't have a slide for it, but this is a project which is about the early detection of neurodegenerative disease. So that really is the detection many years in advance of people who are tending to, or are at high risk of having dementia in their later life. Dementia, of course, is a disease which affects a large part of the population as we get older, but it is a cruel disease in the sense that you can only do something about it if you detect it a long way in advance. And by the time most of us have symptoms of it, it is too late to do anything which can reverse or even halt the decline. And so this EDON project is a large project. Many universities in the UK and the Alan Turing Institute again, to use digital devices, things like Fitbits and information collected through mobile telephones and EEG headbands that people will wear, in order that we can try to detect these quite weak signals of neurodegenerative decline many years in advance of people becoming symptomatic. One of the intellectual property questions that is arising here is, and I think this is true throughout emerging technologies, is that we are going to train neural networks, those sorts of deep machines which are able to make useful predictions, and they will be trained on the data of people who participate in our studies. And of course, those people have the right to withdraw their data at any point throughout the study. And so one of the questions which exercises some of us is who owns the intellectual property which arises from a person's participation, their volunteering of the data, and then when they remove it, do we now have to retrain all of those machines which have learned using that data? And this particular study starts to become not just a sort of scientific endeavor in universities, but we also have ambitions that this will become a self-sustaining product which can be sold in order to be useful, but also to sustain the further development of it. And so at this point, these questions about who owns what in those types of learned systems where you can't actually trace individuals' data to a particular point in the system, but it is there in aggregate, become quite interesting. I'd like to turn now briefly to a couple of things which I think are where AI and machine learning have their most easy contributions to the new technologies of 3D manufacturing, additive manufacturing. I think the first place is really just in optimization. And so a large part of artificial intelligence and machine learning is in optimizing some quantity. For example, well, the example that I have here is one that I've worked on, which is the design of an engineering artifact to be efficient by, in this particular case, a heat exchanger, which is heating up water, which is cooling some pipes. And in the top right-hand corner, you can see a schematic of those 5 pipes which are bearing hot fluid. They're going to be cooled by having cool water flow over them. And the question here, of course, is where to place these pipes. It's interesting because we can 3D manufacturing provides us, additive manufacturing provides us with the opportunity of manufacturing much more novel and interesting designs that might have been designed by a human who would probably just have arranged them in grids. It also gives us the opportunity of trying to trade off different objectives that we would like to optimize during the design. And so in this case, we're trying to minimize the pressure loss from fluid which flows down this channel, cooling the pipes. And we're also trying to transfer the maximum amount of heat away from those hot pipes into the warm water. And those two objectives in this case conflict. And so there are new AI algorithms which are capable of finding the optimal trade-off between these two, in this case, these two objectives, but possible to do many more as well. There's also optimization. I've worked on this a little bit myself in the just in optimizing the support structures which are supporting the artifact which is being manufactured, and optimization in making the best use of the materials. So how closely can you pack many products which are being made all in one go? I think that's these are relatively uncontroversial uses of AI in 3D manufacturing. I think AI is coming to be used a lot also in the control of 3D digital printing processes. And so here I've just tried to highlight 3 papers which deal with some of these types of things. The first one about the simulation and control of complex materials. So these are complex metal interfaces, which are very difficult to model from a first principles point of view, but this group has been able to use deep neural networks in order to simulate the behavior of those metals as they are in the 3D printing process, sorts of things which are have not really been possible previously. There's a nice idea to do with drug delivery, the middle of these papers, which is to print individual medicines or medicines personalized for individual people. And they are using AI in order to control the processes which are necessary to produce the particular personalized medicine. So the medicine for me and the medicine for you might be somewhat different and therefore require a different control of the processes during the 3D printing. And they are beginning to use AI in order to control those processes rather than having to set each one of them up individually. And then perhaps a more thoroughgoing artificially intelligent or use of artificial intelligence is in closing the loop in the 3D manufacturing process. And so these first two have been these first two examples have been there hasn't really been any feedback, or there isn't any feedback from the manufacturing process to the artificial intelligent agent which is controlling it. But in this third one, this group is trying to print structures onto a biological organ, which, and as the printing is proceeding, they're using cameras and computer vision in order to understand how well the printing process is going, and therefore to be able to modify it under the AI control during the actual printing. And that seems to me to be an exciting new development of the way that artificial intelligence might be used, and much more thoroughgoing than the sort of do some artificial intelligence and then let the machine get on with the printing. I imagine that we'll see much more of that in the future. I'd like to just turn a bit of attention to the sort of computer vision aspects of AI and 3D models. And I think that there have been in very recent years great advances in the generation of 3D models, which of course are the things which go into the production of 3D printing. And I think these will start to raise some of the intellectual property questions. But a couple of examples on this slide and the next one. This one here is the generation of 3D models and re-rendering them under different lighting conditions. But these models are generated from found pictures in the wild. So rather than going and carefully photographing the Brandenburg Gate, which we see here, they have just taken collections of pictures that people have taken whilst they're taking their selfies or photographing their friends at Brandenburg Gate, and from that have generated extremely realistic images, or sorry, not images, 3D models of those of the Brandenburg Gate here, and they're able to do that in many circumstances. So they are from these multiple views reconstructing 3D models, and I think that is likely to have many uses and a large effect on the generation of 3D printing models. There's also It's worth mentioning that I think there will be lots of applications for artificial intelligence for the search of 3D models, to be able to locate models which are like the model that you want. Just as at the moment we're able to do image search, 3D model search, I think, will be a new application of AI. Another really a computer vision development, but this is the use of generative artificial networks, GANs, for the generation of 3D images or 3D models again, and these are finches from two-dimensional pictures. And so here at the on alternate lines, you can see on the top row, and then the third, fifth, and the seventh row, you see pictures which are actual pictures of birds, and then on the other lines, you see generated birds, but only using two-dimensional images rather than full 3D scans. I think this too, using these generative generative adversarial networks which try to generate the model and then have a critic which criticizes the model which has been generated. These are very good at producing artificial pictures of realistic faces, and I think that they will soon be used to generate 3D models such as this rotating finch that we see here. So really, I think I see, just in summary, I see uses for artificial intelligence and machine learning in 3 dimensions of finding a place in the 3D manufacturing world around optimized design. I've talked about control and adaptation of the printing process itself, and computer vision for generating 3D models. I think on the question of intellectual property and copyright, I think that there are lots of emerging technologies which are easy to use in the digital domain. And while we have digital models, it's relatively easy and straightforward to watermark those, to characterize those, so that they are traceable, that we can see what the provenance of one model is. There's work on tracing the evolution of models as they've been constructed and modified. All of that sort of thing, I think, in the digital domain is relatively easy. I think that the difficult part, and I'm sure everybody here realizes that, is the interplay between realizing a physical model, a physical artifact from those digital models, and then bringing that back into the digital world, where there is a loss of resolution, a loss of the underlying mesh, and so on, which makes it difficult, therefore, to trace provenance. Okay, well, I think that's all that I would like to say at the moment. I hope that is, well, at least and somewhat useful to this workshop. So, happy to try and answer questions if that would be useful.
Marvelous. Well, thank you, Richard. That was a very, very great presentation. Learned a lot there. So I think we have time for, I think we'll have to say 2 questions, maybe one from online participants and one from participants within the room. So maybe if we start with online participants, does anyone want to ask a question? It'll be first come, first serve. No? Okay, if not, let's go to the room. Does anyone in the room have a question?
Any question here? Yes.
Hello, I have a few, maybe one question about AI, about 3D printing actually. Actually, first time I know about 3D printing is when I was in high school. I know it from a TV series called Elementary. It's that a criminal make a gun by 3D printing machine, and when the cops come, just hide it in the fridge and make it melt in a chemical liquid called acetone, I think. So maybe I think 3D printing has some ideas about sustainable development. So could you just extend it a bit about that? I'm not quite sure. I just want to know. Sorry.
I mean, I think there are possibilities for sustainable development, but it's really 3D printing seems to me to have its large application in personalization and customization, because at the moment we don't do very large 3D print runs. So I think that we are able to produce sustainable products in the sense that we can manufacture things for very small numbers of people, which wouldn't otherwise have been possible. And I think that's probably where the sustainability comes from. I'm not sure that 3D printing, the sort of easy recycling of those materials, and lots of the materials are not terribly recyclable or reusable. I'm not sure that there's a great case for 3D printing to be sustainability in that way. Is that what you were getting at?
Yeah, kind of. Thank you for your answer. Thank you for your answer.
There's also a great story written by Roald Dahl where somebody murders her husband with a frozen leg of lamb meat, and then unfreezes it and cooks it and feeds it to the police who come to investigate the murder. So that sounds to be along the same lines as your story or your show.
Thank you. Thank you.
Okay, well, thank you for that. Great. So I think what we'll do is we will stop here for Richard's section, if we're all okay with that. And then for the purpose of making sure we stick to time, I'll hand over to Hing-Kai for our next speaker. So thank you very much, Richard. That was absolutely marvelous.
Thank you,
so
Richard.
virtual clap for you.
And thank you, James, as well, of course. So without further ado, allow me to introduce the next keynote speaker, Professor Zhongfang Ma. Professor Ma is a professor of international law at Law School Fudan University. He is also a visiting scholar at Max Planck Innovation and Competition Law Institute, Columbian University Law School, and Korea University Law School. His research or academic interests are public international law, international environmental law, and intellectual property law in international trade. Before becoming a member of the faculty of Fudan Law School, he has been working as an in-house legal counselor for 4 years. He has published 11 monographs regarding law and technology transfer and IP law as well. He has published a lot of work, and some of the representative work appear in reputable journals. So I'm not going to go through all the list of his publication. Probably that will take you to the end of this workshop. So without further ado, may I invite Professor Ma to share your keynote speech with us, which is on licensing contract regime for 3D printing in China. Professor Ma, please.
Okay, thank you a lot for Professor Hing-Kai to invite me to prepare to participate in this workshop because of epidemic situation in Shanghai. So I could not participate in the workshop on site. I hope that the effectiveness of this petition will be the same. Okay, so my talk is concerning licensing contract regime for 3D printing in China. this is my brief introduction, and Professor Hinke just give you the brief introduction. Okay, so next is the content. First, I will just try to give you introduction, and especially we're concerned some issues concerning IP issues concerning 3D print. And there is the licensing contract regime on 3D the print in China. Now, first, I just give you an outline, the framework of the license contract regime, and then the definition of technology assignment and the license contract. Of course, I will focus on the license contract. And then nextly, the types of technology assignment and the license contracts. And then nextly is the contents of the contracts. And especially obligations of the licensor and the licensee. And then is the specific exploitation license contract. And the last one, we just talked about the open licensing. Which is a new content to the patent law of the PRC. And last one, we talked about provisions of technology trade, the prohibition against the illegal and monopoly technology now. So we know that 3D now, 3D the printer will refer to active the manufacturing process in which successive layers of the material laid down and compute control to form the 3-dimensional objects. So from this definition, we can find that there are two aspects we shall be focused on. The first is 3D printer, and the second is 3D print software. So for the former, it will concern the patent technologies, and for the latter, it will concern the copyrights now. So before the printer begins, a digital design file for a particular object is either created by the computer-aided design, the program, or by scanning an existing object with a 3D scanner. So it is easier for the IP right holders to be infringing. So especially without the permission of the IP right holders, and it will produce the illegal impacts to the IP right holders. So we can find that sometimes it is very important for us to enhance IP protection for the 3D in front first the printer now. So this is a very general survey for the markets now, which had ever been made in these two industry reports. Now, because these two spots were made in Chinese, so here I just give you a chart to demonstrate that there's a great value for the markets in 3D print in China now. So you can find that in 2016 now there were only about 5.38 billion renminbi yuan, and in 2021 it will rise to 25.18 billion renminbi yuan now. And this is some utilizations of 3D printing in industry. The professor have just give us very expectations for 3D printing and AI. But here we just give you some examples now. The first is the health care now, which have already been very popular in 3D print industry. And the second is the education. You can find that now this have already become very important for the students at different regions now, different regions. So and also for the different ages now. So this just to give you some example to illustrate the 3D print plays very important. And the next is the aerospace now, aerospace, and the next is the automotive now, automotive, and then next is the construction now, and next the manufacturing now. So all of these are and next is the robotics now. All of these are the examples that utilize of the 3D print in industry. Now we can find that, for all these examples in industry, now you can find that there are at least 8 characters of 3D printing. Now the first is that it does not need the centralized and fixed manufacturing workshop and has the characteristic of distributed production. And secondly, it can take the shape in a few hours, allowing the designers to make the leap from plan to entity. And thirdly, they can print the assembled products, greatly reduce the assembly cost, and even challenge the modes of the mass production. And then actually there is no need to eliminate leftover materials, improve the utilization rate of the materials, and reduce the cost by abandoning the production. And also it can achieve the higher precision and higher complexity, and can manufacture very complex parts that cannot manufacture by the traditional methods. And the next is, without the traditional cutting tools, fixture and machine tools or models, it can directly generate 3D CAD graphics of any shape in the physical products. And it can automatically, quickly, directly, and accurately convert the 3 dimensions into the physical model, and even directly manufacture parts or models now. And the last one, its integrated forming feature can be used to optimize the structure of complex the machines, like increase the service life and improve the performance. And in my one word, the characters of 3D print can be generalized as individualization. Now, it can meet the special demands of individuals. So, actually, the issues concern the 3D printing. The special consideration for 3D technology. The first, we can find that it is easy for the infringer to utilize the technology or other IP now. So easy to find, sharing, and the low cost of making 3D copies of objects of technology become cheaper. And individuals manufacturing items by copying files illegally obtained by 3D scanning and objects for personal use or for sale. And individuals customize objects or printed their own spare parts. So all of examples now to illustrate that it is easier for the infringer to utilize the property rights, intellectual properties of IP right holders now. And then there are some special considerations for 3D technology now. When a company licenses 3D print technology, whether to limited scope of the licensee's use, for example, most occasions some people believe that the 3D printed may develop a great challenge, legal challenges to the IP legal systems. So that's the reason. The first is the risk of violating IP rights of third parties, and then protecting the own products against 3D printed counterfeits. And then the next is the issue of the copying and fair use. And the next will be will 3D print challenge the existing intellectual system. So I had ever published 2 papers in Chinese now, which just try to illustrate that, in my opinion, the 3D print will not launch the great challenges to the current legal system on IP protections. That means the IP protection now can meet the demands of the development of 3D print technology. So the example is the contract licensing. That means the contract licensing legal regime may be used to protect the 3D with the IP right holders in 3D industry. So this is the very important idea. That is, contract licensing is the important way to realize the value of 3D printing technology, especially by the utilization or by application of the new technology in this field now. So firstly, the problems on contract licensing in the field of 3D the print. The first is the open source software in 3D printer now. The first is the use of the open source software in 3D print present potential contract and intellectual property, the infringement issues. And the secondly, the contract issues arise from obligations and restrictions that may be imposed by the open source software agreements. The next, the intellectual property infringement contains the risk that software applications and content files may include material subject to third-party copyright rights. That is copied without the agreement or permission or authorization into the software or 3D design file. In addition to the copyright infringement risks, the third-party trademark and patent rights might also be incorporated into 3D design files and ultimate printed objects without authorization from the right holder. So, and the next question may be raised for us to consider further. The first is the 3D print of the spare parts via IP license contracts. It's possible or impossible now. So in my opinion, maybe. So let's just try to give you the very brief introduction of the licensing contract regime on 3D print in China. We know that now this regime has already developed comprehensive and systematical regime for license some technologies concerning 3D print. This is a very framework of IP licensing regime for 3D print in China. Now, first, we should notice that there are many provisions concerning the technology licensing or technology assignment in civil code. Now, the first is the Article 843 to 850. Now, in these articles, just try to develop a very general rule for the licensing or assigning technology. And then Article 862 and 877 will focus on the technology transfer contracts, especially technology license. So here transfer in the contract law which made in 1999, the technology transfer may include assignment of technology and the license of technology. But in civil code, there is the distinguishment between the technology assignment and the technology license. So now we have a specific definition for the technology license contracts and technology assignment contracts. But originally, most people believe that the technology transfer may equal to assignment of technology now. And then Article 94 just focus on the dispute settlement. And then the second very important law is patent law. Now, in this law, we have a very general provision, that is Article 12. And then we will focus on Chapter 6, will give us some special licensing for exploitation of patents. So there are about 8 articles. And then because for some intellectual goods concerning 3D print may be categorized into the copyright works. So we shall also know some knowledge about the copyright law. And in copyright law, we have about 2 articles concern the licensing, the contract for the works. And there are other laws, for example, foreign investment law and technology important export regulations can also provide some provisions concerning the technology licensing for 3D printed in China. So this is just to give us a chart to demonstrate what I have talked about now. The civil code, the patent law and copyright law and other laws and relevant regulations now. So especially there is a very important legal documents for us to deal with the licensing issues concerning 3D print. That is the interpretation of the Supreme People's Court on several issues concerning the application of law in hearing cases of disputes over the technology contracts. So the next slides will just focus on the laws for this implementation. The provisions in this implementation, I just provide them for the audience as the reference now. So first, we know some knowledge or some provisions from the provisions of the civil code. Now, the first is in the civil code. Now, it is provided that a technology contract is a contract made by the parties to define their mutual rights and obligations for technology development, assignment, licensing, consultation, or services. That means in the Civil Code, we have 4 types of technology contract, and assignment and licensing are the 2 types, especially the licensing play a very important role now. And then for the technology license contract, that means a contract whereby the law for the owner of the technology authorized others to exploit and use the particular patent and the technical secret. So technical secret on most occasions shall be referred to know-how. And the agreements on provision of the special equipment and raw materials for implementation of technology, or provision of the relevant technical consultation and services in technology transfer contracts are integral parts of the contract. So you know that this is the reason why the United States try to utilize the export control, the regulation to control some materials to be exported to other countries because they think that this special equipment and raw materials may contain some technical factors, and so it is easier for us to understand why in this Civil Code, when we give the tabulation of technology contracts, this can also be regarded as integral parts of the contract now. And lastly, you can find that technology license will just focus on the right of utilization. So it is quite different from that of the technology assignment contract, which may transfer the ownership of the technology to somebody else. So this is quite different now. But according to my the research for the more than 20 years, I found that in the practice, there are more contracts concerning the technology licensing and there are fewer the examples concerning technology transfer or assignment. And this is the petition, the interpretation of the SPC, just to try to give us a further explanation of the definition of the licensing contract. So we do not have enough time to do this, to go over this one. So this will be left for you to add the reference now. And then we can find the types of the technology assignment and the license contract. Now you can find that technology license contract includes contract for patent exploitation. Now the license, the contract for license of the use of technical secrets now. So you can find that when we're talking about licensed contract, on most occasions it will just concern the rights of exploitation or application. It will not concern the ownership. And according to Civil Code, now the technology assignment contracts and technology license contract shall be in written form. So the oral contract in this field will not be accepted now. And then this is the further explanation or the further specific provision concerning the contract of license technology. The first is the Rule 14 of the implementing rules of the patent law, and the second is also all of them are concerned the patent law. So we can find that it will just try to tell us how to effectively enforce the patent law or the provision concerning a license contract in Civil Code. Actually, we can find that when we do some transactions concerning the patent technology, the technology assignment or license, it shall be registered in the Patent Administrative Department. Now we know that today this department on most occasions refer to SIPO, that means State Intellectual Property Office now. And also now you can find that the department, the patent department, shall also publish the patent gazette at the regular intervals, the publishing announcing the following items. So you can find that the patent license contract for exploitation submit for the record. That means any patent license contract shall be submit to the patent department. And then nextly is the contents of the contract, license contract. The first is the conclusion of the technology contract shall be conducive to protection of intellectual property rights and the advance of science and technology, and shall promote the research and development, commercialization, application, and dissemination of the achievements in science and technology. So this is a very general principle now, which is newly added to the Civil Code. In the contract law made in 1999, we do not have this. We did not have this article now. So you can find that this article utilized here is just a try to focus on the balance the right holders and the users of the IP right holders and the public now. So nextly is the items of the technology contract should be at least contained. Of course, this is just as the recommendations now. So a technology contract generally contains clauses now specifying the name of the project, the content, scope, and requirements of the object, and the plan, the place, and manner or of the performance, and the confidentiality of the technological information and the materials. And next is the ownership over the technological achievements. Now, especially concern the technological improvement on the basis of the license contract, and the methods of the proceeds distribution. And nextly is the criteria and the method of the inspection for the acceptance, interpretation, and the like. And you can find that there is no items, there are no items concern the royalty fees or concern any price terms, and also it does not concern any the performance of the price, the Y, because we know that all of this one can be negotiated by the parties. So in the Civil Code, now the legislature will not enlist these two items as the recommendation list. But in 1999, there were two items I have mentioned in this provision now. And the next is the technology license contract may stipulate the scope of exploitation of patents or use of the technical secrets. So that means when we're talking about the rights of technology, we know that it is most occasions can contain at least 5 kinds of rights. For example, the manufacturing, application, sales, and after for sale and imports. But when we're talking about the license contract for such kind of rights shall be specified now. So actually just try to give us the interpretation of the CPC, of the SPC, give the further explanation to this article now. So you can find that the scope of exploiting the patent or using the technical secret as mentioned in this article, it shall include the time limit, area, and method for exploiting the patent or using the technical secrets and personnel who have access to the technical secret. So you can find that it gives us a very detailed information concern such kind of contract now. Okay, now, and also you can find that there is a very general provision that is a technology contract which illegally monopolizing technology is invalid. Now, that means if the contract violated the antitrust law, and then this contract may be regarded invalid. So next is the examples. That means the interpretation of the Supreme People's Court just try to tell us what kinds of situations should be regarded as illegally monopolizing technology. So all of these one can be demonstrated and at the interpretation for us to understand the illegally monopolizing technology now. So we'll not go with this one now. Okay, now. And then in this article, it also mentioned that the contract law shall not, the contract agreement shall not restrict technological competition and technological development now, especially for the subsequent improvement now. So and again, now this is just to try to give us the further explanation of the license for exploitation of the patents now. So give us the several types now. Firstly is exclusive license and the sole license and the simple license. So this is three very typical types for of the licensing. But here it is give us a very clear definition that the provision that where there are no stipulations between the parties on the way of the patent exploitation license, or such stipulations are unclear, it shall be deemed as a simple license. So this is a very the mandatory provision. That is, if there is no very clear stipulations in the license agreement, and that a simple license shall be granted. Okay, now, and also the ways of a license for using the technical secret shall be determined by the provisions of the paragraph 1 and paragraph 2 of this article. And then this give us the other further explanation. That means if there is no very clear the stipulation, and this interpretation will give us a very clear selection. Okay, and then we know the obligations of the licensor or the licensee now of the assignment now. The assigner and the technology assignment contract or the licensor and technology license contract shall be guaranteed. That is the lawful owner of technology. So this is very important. That means the licensor shall guarantee that he or is the lawful owner of the technology now, and shall guarantee that the technology provided is complete, is free from error, is effective and capable of achieving the prescribed goals. But we can find that this is a very generic provision. It's difficult for the parties to make the right holders guarantee is a reality now. And then next is the Article 26 of interpretation of the SPC to try give us some complementary provision for this one now. The licensor and the contract on the license for exploitation of the patent shall bear the obligations of maintaining the validity of the patent right with the term of the validity of the contract, include what. Then again, it shall be regarded as the further interpretation of the obligation of the licensor. And then any patent rights that had been declared invalid shall be deemed to be non-exist from the beginning. So we have the very clear definition in the patent law on such situations. The right holders may not have the right to claim the further rights. Where the patent infringement compensation, royalties, and patent rights transfer fees are not refunded pursuant to the provisions of the preceding paragraph, which constitutes the blatant violation of the principle of fairness, and then the refund shall be made fully, partly. That means when the licensor have found there are some mistakes for him, and then it shall refund the money, And then this try to tell us some the obligations for the licensor now. So please attend the second Article 8 165. That means the contract for patent exploitation license is only valid for the term of the patent. Now, this means only the patents are within the protection term, and then it can be regarded as this contract should be regarded valid. Where the term of the patent expires and the patent is declared invalid, and then it cannot conclude the contract for patent exploitation license with another person. And the licensor and the contract for the patent exploitation license shall, as agreed in contract, license the patent to the licensee, and it shall also deliver the technical materials related to the exploitation of the patents and provide the necessary technical guidance. Now, that means sometimes it shall provide the technical helps on site. Now, the licensee and the contract for patent exploitation license shall exploit the patent as agreed in the contract and may not license the patent to any third party except as agreed in the contract, and shall pay the royalties in accordance with the contract. So this is the obligations of a licensee. Now, please attention here. Now, that means without the permission of the licensor, it cannot illustrate. It cannot make any license agreement to a third party. And the second obligations of the licensee is to pay the royalties. And this is the interpretation for this article. So we do not have time to go with this one. And then next is again talking about some of the obligations of the licensor. And the licensor and the contract for licensee of the use technical secrets shall, in accordance with the contract, supply the what you can find that it shall provide the complete information concerning the technology, including the patented information, and also containing some know-how and even some the other knowledge concerning the technology. The obligation of confidentiality stipulates that the preceding paragraph shall not restrict the patent application by the licensor unless otherwise agreed between the parties. And lastly is again give us the further interpretation of the articles in the civil code. And then where the licensor fails to license technology in accordance with the contract, it shall refund the royalties in party or in whole, and shall liable for the breach of the contract. Of course, this is the important, or may say the most important legal liability for the licensor. Where the licensor exploits the patent or uses the technical secret beyond agreed scope or without authorization, the license a third party to exploit the patent or use the technical secret in violation of the contract, it shall seize the breach and be liable for the breach of the contract. Now, where the licensor breach any agreement obligation of confidentiality, it shall be liable for the breach of contract. So this just try to give us describes the legal liability of the licensor, and also we can find that there are further the provisions concerning the obligation of a licensee. Where the licensee fails to pay the agreed royalties, it shall pay the overdue royalties and pay the liquidated damages in accordance with the contract. Now, when it fails to pay the overdue royalties and liquidated damages, it shall cease exploitation of the patent or use of technical secrets. So you can find that this may be regarded as parallels the liability to let off for licensor's liability. If where the licensee exploits the patent or uses the technical secret beyond the agreed scope, or unilaterally allows the patent to be exploited or the technical secret to be used by third party without consent of a licensor, it shall seize the breach and be liable for the breach of the contract. Now, where the licensee breached any agreed confidentiality obligations, it can also be liable for the breach of contract. So you can find that in civil codes now, we pay much attention to protect the confidentiality of the obligation, confidentiality for each parties. So we may regard it as this may be influenced by the signed United States the agreements on the economic and trade cooperation, which made in 2020. Now we know that this agreement was adopted on January 15th, 2020, and the civil code was made on May the 28th, 2020. Now, so we can find that in the agreement between the United States and China, that agreement emphasized the significance of protection of protecting the trade secrets and confidentiality. So you can find that this one can be reflected in these provisions. And also the Article 874, where the exploitation of patents or the use of technical secret by a assignee or a licensee in accordance with the contract infringes on the legitimate rights and interests, and then this licensor or the license assigner shall bear the liability. Now that means it cannot guarantee the licensee or assignee could gain the benefits from this confidentiality now. And the parties may, on the basis of mutual benefit, provide in the contract for the methods of sharing and subsequent improvement made in exploitation of the patent or the use of technical secrets. And that means if there is no very clear definition or clear provisions or stipulation in the contract, and then the Article 510 shall be applied. So you can find that in this article, the relevant terms of the contract or the customers shall be governed. That means if there's no stipulations in this aspect now. And this is interpretation of a CPC concerning the legal effectiveness of the contract. So for this one, I will just left for you to as a reference. So, and then also give us some further explanation for the technology contract invalidate or rescind now. Okay, now because the time is limited, so we do not will analyze these specific issues now. And the next we're just talking about the open licensing patent, which is the contents for patent law now. The open licensing means
So I'm sorry for the interruption. I'm just curious of time, so if possible.
I'll go over very quickly. Okay, now. Okay, now. So this is the voluntary declares in writing to the patent administrative department or what? So that means as soon as the patentee gain granted the patent, and then it will make the announcement. That means if anyone want to license the patent, and then it will just give the notice to the department, and then it can gain this agreement. I can give this the license now, and then you can find there are very detailed the provisions according concerning this one. And the next is the compulsory license for exploration of the patents now. So you can find that this is also the typical terms from the TRIPS agreements now, and that this is the general the provisions concerning the licensing in copyright law. You can find that there are very specific definitions of the copyright licensing now. Okay, and then you can find that the economic rights can be licensed concerning the copyright. So this is dispute settlement. Now you can find for the prescription, the period is 4 years. Now it's quite different from that of patent law now. And then next is the provision of technology and regulations. So we can find that this may be regarded as the government's the control of the regulations now concerning licensing. especially concerning the state security, it will be restricted to import or export. So this will just provide you as a reference. I will not go over this one. And then you can find that we have some the policies concerning technology, the trade. Now we can find that prohibit technology and restricted technology and unrestricted technology. This is free now. And the 3D print may be regarded as the printed technologies now, which may be exported. If you export the technology to the foreigners, it may be prohibited now. And then this regulation concerning the catalogs of China's prohibited restricted technologies now, which made by the MOFCOM. Now, okay. Now this is the other provisions now. So for this one, all prohibition against the illegal monopoly of technology, we have already mentioned this one, and this just provide you as a reference, so we'll not go over this one. And also you can find there are very specific provisions concerning the IP, the license issues now. Okay, now, and then the written form, I just mentioned that, and the consequence of the violating mandatory, you can find that on most occasions, if the violating the mandatory rules, the contract may be regarded invalidated. And this is the other further explanation for these issues. And you can find the consequence of violating the mandatory rules. We can give the further determination, interpretation now. And the last one is just the conclusion. The 3D print is a very significant industry in China, and they are. This is a very the reality. And the second is they have no specific provision on license contracts on 3D printing in China, but the provisions are scattered in the different laws and regulations, which constitute a comprehensive and systematic regime on licensee IP rights concerning 3D print. And the licensee 3 contract regime on 3D printed in China can not only provide reasonable and definite guidance for licensee 3D printed in China, but also can provide the adequate protection for IP right holders in the field of 3D print. In my opinion, the legal regime on the contract licensing concerning 3D in China is sufficient to protect the IP holders now in China. Okay, this is my presentation. I'm sorry. I hope that I will not waste of your time. Thanks, Professor Hing.
Thank you, Professor Ma. It's all right. We just worry that I know you have another online event to attend, so I don't want to overrun the program and then you cannot attend the other event. So again, questions from the floor. I guess we can only accommodate one question. First come, first serve. Oh, I see Ernest here.
Good afternoon, Professor.
Yeah.
Just 2 questions, I think, both about fair use in this area. So one of the key things about fair use is the transformative nature of what the potential infringing party is doing with the material. So let's imagine that you have company A and company B and company C. So company A has the IP for the technical process of printing something, and they license that to company B. And company B does 2 things. One, they use that technology in their research and development to further their own technology. And 2, they accidentally, of course, leak on Google, and then a third party uses that to develop their research and development. How would fair use work in those situations in your view?
So in my opinion, that will depend on the creation on the basis of the technology licensed to the other parties now. So in my opinion, you know that when we talk about the licensing, this transaction, on most occasions, it shall be helpful to a licensee, or this transaction will be just the like that of transaction of goods. But you know that on most occasions, the licensor will not allow the licensee to make the subsequent improvement on basis of the licensed technologies. So in my opinion, if the licensee makes some subsequent improvements on the basis of the licensed technologies, and of course, that means how much or what extent the creation made by the licensee will be another question. So I have ever read some cases concerning that if the licensee make the new creation about 10% of the technologies, and it may be regarded as a new the patent technology. If he applied for the patent, it can get patents because it makes the contributions to 10% now. And this is one the factor. And the second factor is if the licensee does not utilize this one to in the commercial activities, so something it cannot be regarded as it can be regarded as fair use now. You know, especially in China, when we talk about the fair use, it shall not make concerning make the have nothing to do with the commercial activities now. So this is just my response to your question, and thanks, thank you very much for your interesting questions. Okay.
All right. Thank you very much, Ernest, and also Professor Ma. I look forward to seeing you next time in person, okay, either in Shanghai or in Ningbo. Thank you very much for your presentation.
Oh, thank you. No, thank you.
Yeah. So let's move on to the next presentation. Actually, it's the introduction to our HRC project. As I mentioned at the early beginning, this is a joint event, okay? Joint opening event, okay, of a kick-off event, I should say, of this project. So James, are you going to control the slide?
Yeah. I've got a problem at my side where it seems I cannot share the PowerPoint. So maybe if you can start sharing it your side, and then
sure,
I can best control.
Yeah, sure, of course. Xinbin, can we share the slide here?
Yeah.
You just let us know when you want to move to the next slide. All right. Okay, I will let you start first.
Okay. I'll have to tell you when I want to move slides because it says the control. I can't request control for some reason. So just so you know. Okay. Right. Well, marvelous. So thank you very much, Hing Kai. As I said, nice to see so many people here, and also lovely to see Onyeka here in the audience. Onyeka is the designate head professor at Essex Law School. But he's also been acting as a co-I on some of this funding. So today we will be talking about our projects. So following on from the earlier presentations, I will begin with this and then pass over to Hing Kai slightly over halfway through. So we can go across to the next slide. So these are all of us, most of us, on the project. Hing Kai is PI on the LEADAC Sum Fellowship side. I'm the PI on the AHRC side of things. Our projects run in parallel, and they are effectively seeking to achieve very similar aims, hence where we are collaborating on this. It's very much an international project where we have equal amounts of input from the UK and China. So by way of background about 3D printing, next slide, we already had Professor Ma talk about how 3D printing has grown as an industry in China, and of course it's done the same thing in the West. There's also something else though that we ideally should think about, and that is that 3D printing is not only just simply growing, but it's also covering more and more fields. So right now, today, for example, it's very large in the fields to do with aeronautics and dentistry, but also within other fields like car manufacturing. But it's also enabling more and more digitization through 3D scanning, for example, but also just simply enabling more innovation in more industries. So not only is it growing in size in existing industries, it's also covering more novel and new fields as well. So this has led to a lot of press naturally about the topics. Next slide. And then 3 more clicks. So we have a lot of press, for example, these sorts of things that will be appearing at the bottom. And during the course of this, we have more and more standardization occurring. We do have a standard file format, which is STL, which many of you in the audience will probably be familiar with. But there have been attempts to have an STL-like file format, including intellectual property, though they've not been that popular. But we also are looking at standardization more at the licensing side, which is the main focus of our current projects. So we are looking at whether or not there can be a standardized form of licensing using a system such as blockchain, for example, to link blockchain through to 3D prints, both the physical 3D print and also the file formats. So we want to enter into this to help standardize this licensing, provide a technical standard, which can then be utilized by companies and individuals wishing to share the content that they have created. So next slide, please. One more. So our system then introduces something new, which is this thing on the right. So a traditional system is on the left. This is where you would email a file, for example, to a 3D printing company or download it from a server. And you then ask a company to print out that file. Many of you have probably already used these sorts of services online, things like Thingiverse, where you can get links through to companies that will print the files. So that's the system on the left. That's a traditional system. So our system is a little bit more decentralized, and so we're providing a second stage, if you like, within all of this, which is this blockchain element that can, as it says on the top right of this left of the right-hand diagram, lead to more authentication, trading, storage, and also dissemination of content in new and novel ways. So we're linking up blockchain with 3D printing. So there are 2 steps to achieve this. Next slide. And these are points 1 and 2 on the next slide. And the first point is one that we have already developed under a previous AHRC project. So this is developing some watermarking technologies. We'll be taking this further in this project as well. So we have a patent over the watermarking technologies. And then secondly, we'll be taking that technology and using it within the licensing systems, and we will be implementing this in practice. Next slide. So on the first point, the watermarking technology, some of you will already be familiar with this, and may have even heard me talk about this before. This may be familiar to you, but it won't be familiar to everyone, hence why I'm going through it again very, very quickly. So we have here on the screen what we might call a very traditional watermark, a paper watermark. So this is a banknote, and it will help identify the banknote as genuine in the same way that a watermark in a book might help to identify the book as a genuine copy. But I mention a banknote here specifically because this is an example that watermarks can be more than just merely passive. So a watermark in a banknote is by law required to be detected by a photocopier. That's obviously to stop people photocopying money. The photocopiers will detect this watermark, and it will prevent you making a photocopy. So if any of you ever thought about making yourself rich by photocopying cash, I'm afraid it won't work. So that's one example of a watermark being used in a technical way to prevent unauthorized reproduction, which of course is very similar to the use of a watermark in a copyright context. Next slide. So this is an example of a digital watermark, purely digital. So this was a competition that's become reasonably well known now, it's since finished. It was for a hacker group and they were using watermarks as part of their competition. And so what we have here is a really good example of a basic watermark. So what we have on the screen appears to be very simple text, doesn't it? Just writing, like in a Microsoft Word document. But you'll see, third line down, it says the first clue is hidden within this image. So it's an image, it's not actually text. And this was a clue that maybe you should do something with this thing that's on the screen. And the first thing that people tried was to increase the brightness. So they took the image, put it into an image editing program, and increased the brightness on it. Next slide. And this is what showed. Okay, if you look really carefully, you could actually see this with your own eyes in the last picture if you look really carefully. So this was another clue that there might be something more hidden in this image. Next slide. And so this was what was hidden in the image. It was text that somebody had typed in. You'll see there's a lot of black in that picture. That's how they were able to do this. And so this was more text, which was another clue. After this, it was things other than digital watermarks, so we won't look at those. But this was a clue that people should look up some information in a book. The book is there's a picture of it on the right there. So you can do this with any picture, video footage, computer software, anything. And I've shown this before in some of my classes, where you can take a picture, load it up into a program, insert some text, upload it to the internet, search for the text on Google. After a while, you'll find that picture or whatever it is. Yeah, and this can be done on an independent basis for each user. So when you access, for example, films on Netflix, on iTunes, you can come across watermarks embedded in those that will identify the user. So if you make a copy of anything that you download with these services, it's possible to identify who made the initial copy. So, you know, of course, quite often, if a copy of one, say, Hollywood film is made, it gets shared more and more. They still come from one source quite often. So this enables you to work out which specific user it is who's being very naughty. So that's the purpose of watermarking like this. It enables you to establish the point of infringement. So this is a simple digital watermark. Next slide, please. So this is a 3D printed watermark. So we developed this. What you've got on the screen right here was some of the existing technology in this area. We combined a lot of this together, and that's what we'll show in a moment. But it just gives a very simple example of what the sorts of things we're doing. So you can change the outside of a 3D printed object. You can change the surface of it. You can change the internal structure. And you can make this unique using the sort of mathematics that you've got on the right-hand side of this. Obviously, it's out of context, but it won't make any sense. But basically, it allows you to change the various printing points, for example, in an STL file. The trouble is, STL files are very basic. They're basically just X, Y, and Z printing points. So we need to do something more than that if we want to make this completely foolproof. So we can change the way a printer prints. We can change the code that a printer uses to print. So if you want to print something with an STL file, you still have to change that file to make it in a form that the printer understands. So you can interject at that stage. You can still insert data into an STL file, but you've got to obfuscate it, so it's not as efficient as it was. So you can do these various sorts of techniques, and you don't need to put the full information into the 3D print. You can link it up by some other means into a blockchain. So next slide, please. So this is the patent that we obtained previously. You can find this on the internet and have a closer look at it, and you'll see there the sorts of things that we are doing application of mathematics to change some of these points within the file. So we showed this and it can operate reasonably well. This is what we demonstrated on our conferences in 2017. Next slide, please. Now, an interesting point with this, for me, from a lawyer perspective, just very quickly, is the fact that we have some international law that effectively gives extra strong protection to a watermark like this if it involves copyright content. So in the second paragraph here, there's a reference to information about things like the name of the author, distributor, the sorts of things that are permitted with a work. Now, if those sorts of things are in a file in or associated with a 3D print, for example, of the sort that we were just looking at, there is automatic protection over it. And you don't even need to go through all the complicated stuff to do with copyright infringement or contractual infringements, etc. You don't need to do any of that. You just need to prove that somebody has altered the information or taken it out with some knowledge. Knowledge has been difficult to prove in the past, but it probably won't be soon, because the way the technology works means if it's removed, you probably have removed it with knowledge, particularly if you can trace it back to the first person who's altered it. So this is, anyway, legally very significant because it means where we're dealing with copyright issues, and copyright covers most things on the internet, there will be this additional level of legal protection specifically over the watermark. That actually has potential to be overreaching and overbearing. Okay, next slide, please. So that's the first part that we were just looking at, the watermarking technologies. So let's move on to the second bit, and then one slide's time, I'll pass over to Hinkai. So the development of the blockchain part, so the second element now. So yeah, the red arrow is, so the means of enabling the licensing of the content online. So next slide, please. So blockchain, we can use blockchain. Blockchain can potentially be copyrightable under exactly the same law that I mentioned if it is for the purpose of identification. If you don't know what a blockchain is, because we talk about it a lot, but without necessarily understanding what it is, you can look online at this GitHub page, which has some quite interesting examples of what a blockchain is and how you would code a blockchain. So we can use these blockchains to help identify the 3D prints. It can be novel and unique for each and every print, and it will help be able to establish a chain of causation, if you like, a link between all the various uses of 3D prints. So in evidentiary terms, it's very, very useful, and therefore in terms of licensing. So I think I can pass over to Hinkai now to just carry on about the blockchain element.
All right, thank you. I probably will go through the rest of the slide quite quickly because I'm cautious of time. So basically, the second part of this is more about the LeaderSum Innovation Fellowship project James mentioned at the very beginning. But in fact, I'm not a blockchain expert. We have Dr. Lei Hao over there, who is one of the project team members here. His expertise is more on blockchain rather than I do. But blockchain here obviously can help us to implement the watermarking system, as James just mentioned. Well, the pattern we developed basically is the watermarking method. So it's nothing about authentication or, the way to protect IP. So that is the technical bit. So, in order to implement it or commercialize it, if you like, then we need a vehicle, and blockchain system here is the vehicle. But of course, we also understand that blockchain here cannot do everything. So we understand that it's not a silver bullet. So that's why we need to develop this system very carefully. So we are going to develop a 3D printing authentication platform design system, okay, based on our patent technology, which is about watermarking, and merge this technology with the blockchain technology for that purpose. So basically, you can broadly divide the whole platform into 3 bits. Okay, the 3D printing digital model, which is about the encryption or watermarking part. And then the middle one is the blockchain bit, okay, which is the authentication service, okay. And then, of course, we also need to connect to the customer at the user interface. And I'm not going to discuss this further, but this is kind of the schema of our system. Basically, it consists of the three elements I mentioned: the blockchain part and the pattern technology about watermarking. And the system we are going to develop actually is also able to incorporate visual recognition technology, because after we put, per se, the watermark onto a 3D printed object, a very important aspect is that we need to extract the watermark from the printed object, and this is the visual recognition part. Well, the project itself may not be able to cover this well in very much detail, but at least this is part of the extension of the platform. And of course, we can make use of this to extend application to other digital model, like even video or other kind of digital output. Okay, and this is basically the technical root of this project. Again, I'm not going to go through it in detail, but this outline what we're going to do for this project in the next 2 years, say. Okay, and this is the timeline. We also aim to commercialize this platform if possible after our development. The major objective is not really to commercialize it, but we want to make it available in the market so that the watermarking and pattern technology can help the 3D printing industry further develop. Okay, so this is our expected contribution. Obviously, the watermarking encryption system, and then if this pattern, if this platform is can be implemented, and we can make use of this to develop a trading business system. So a digital platform, that can be, encrypt and protect IP of digital objects, including digital file, video, and etc. Okay, so everything we have been discussing here, including James Park and myself, related to a previous AHRC project. Okay, and that's also led to the pattern James mentioned. So we have organized a couple of events, and we are going to further develop this. Okay, because of this project, we got the funding and support from HRC and Leaderson Innovation Fellowship. So basically, that's all from me. James, do you have any supplement?
No, I'll be quiet.
Okay, so probably another round of Q&A from the audience, both online and offline. Yeah, one question. Okay,
no question actually. In fact, I will just ask a question to Professor Ma. But I have
Professor Ma.
No. I just got the question from the Hinke and the James speech.
Okay.
In some ways, I'm a product designer, and in our design process, we always make models, make 3D models, and we always use 3D printing for our evaluation is our design shape and the human-machine relationships. But we always send the 3D model to the 3D printing company. In this case, we always worry about it will link out our design or use it for the other purpose. So the question I would just want to ask Professor Ma is there any easy way to protect our appearance patent? But through the speech from James and Hinke, I think that with what marking and blockchain is really creative and smart way to protect our design patent, and I hope hope this will come to as soon as possible.
Okay, thank you. So it's not a question. I see it a compliment. Okay, to our project. Yep. So
I could add something actually to that.
Okay.
Yeah. So one thing, when we were doing our previous empirical research in China, we saw a lot of the contracts that were involved, and some of them would assign copyright in your situation to the company doing the printing, but not all. So a lot depends on the company that you were using. So it depends essentially on the contract more than anything else. That's what I would say there. Contract is key.
All right. So any further questions? Well, if not, then do you want to say anything? Okay. So James, do you have any additional comments before we conclude the workshop?
Yeah, well, I'd just like to say thank you for everyone being here. It's been absolutely marvelous. We've got great participation online as well as offline, so that's really good and a good example of international collaboration, I think. So, yeah, so thank you very much to everyone for being here. I really hope you found it interesting and useful. We will be doing more events in the future, and we will, of course, let you know what those are and when they are taking place. So over to you, Hinkai, I think now.
All right. Before I let you leave this room, I would like to thank a couple of people. First of all, of course, our invited guests, okay, who very provide us a very valuable insights on the topics, and of course our project team members who make this project possible, okay, and helper to make this workshop possible. Fong Fong over there, Xinbin, can you move the camera to show Fong Fong and yourself, or you can come over here, perhaps it may be easier. So Fong Fong help us to do all the administrative work, and Xinbin here actually the whole event he is behind the scene because he need to control the online teams and also the PPT, etc. So thank you very much for your help.
Yeah, thank you.
And of course, all the audience, both online and offline, as James mentioned, but I still need to mention it again. Okay, thank you very much for your attendance and your patience. Okay, I know it's quite late, especially on the China side. It's 7 o'clock over. So enjoy your dinner tonight. Enjoy the weekend. And if you have any further comments in the future about our project, of course, you're very welcome to let us know. Okay, so thank you very much.
Thank you, everyone.
All right, bye-bye. James, I will be in touch with you.
Okay, super. Cheerio.
Thank you.